Hello everyone, I am Advocate Sanjay from the LEXIS company. Today I am discussing about the right to vote, a private or fundamental right. Say a justice Rastogi majority judgment opinion it is a circumstantial rights. The Supreme Court decision to reform the process of making appointment to election commission has come against the sparked the debate surrounding the status of citizen right to vote. The Constitution bans comprises Justice K.M. Joseph, Ajay Rastogi, Anirudh Bose, Hirisika, etc. was of this view that right to vote is constitutional right. The four judges' majority, however, refrained from making a final judgment declaring in this regard cited the 216 judgment in Kuldeep Nair versus Union of India, where a bench of coordinate stand had held that there is a no constitutional right. What is important is that the court noted in Anukul the holding of free and fair election constituted a basic feature of the constitution approved of few and that the right of elected in fundamental democratic, even if it is treated as a statutory right, the right is of greatest importance and form the foundation for the free and fair election, which in turn constituted the right of people to elect their representative. We would, for the purpose of this line in question, rested content to proceed on the said basis. Justice Joseph right for the majority said. In this concurrence opinion, however, Justice Rastogi observed that right to vote is not merely a constitutional right but a competent of part third of constitution. He goes on the state that right to vote is not limited only to Article 362 but flow through Article 15, 17, 19, 21 of Constitution. History: the right of vote was denied to women and those were socially opposite. Our constitution took a reasonable step by extending financially to everyone in a way the right to the vote, ensuring the protection granted under Article 15 and 17, the right to take a part in conduct of public affairs as a voter in the Karo or domestic forum of government, which is a basic feature of constitutional right to vote, is expressive choice of citizen, which is a fundamental right under the 19A. The right to vote in a part of citizen life as it is their independence tool or shape their own destiny by choosing the government they want. In that sense, it is a reflection of Article 21. Justice Rasuki attempt to draw a strain from Constitutional Assembly debate which shown that right to vote was initially considered as fundamental right. However, it was lifted to another constitutional provision as two founder did not want to offend in the princeless state with whom they are negotiation to be a part of India. Otherwise, they had stressed the importance of right to vote and universal adult fifth and year after the independence. We had the constitution realized they absolutely wasn't by recognizing what they could do. Socially political circumstances of their time, justice was to be open. Sixteen, the majority took notice of fact that the presidency which held that right to vote is not a fundamental right were not really concerned with this as a prima facie. The bench of six learned judges and MP in the contents of Article 329 we held that the right to vote was a creature of statute. The court really was not a concerned with the question as to whether Article 326 provided for the constitutional right to vote. In Damakanta Pandey, thank you so much guys. We come with a new videos and new session and thank you so much.